It's now 9 a.m. Welcome to the Cities and County Subcommittee of Local Government. Mr. Hutchison, please take the roll.
Vice Chairman Calfee. Present. Representative Chisholm.
Present.
Chairman Crawford.
Here.
Leader Gant. Chairman Helton.
Here.
Representative Miller.
Here.
Vice Chairman Wright.
Here.
Chairman Moon.
Here, present.
Mr. Chairman, you have a quorum.
Thank you. Do any of the members have any personal orders? Seeing none, we'll go ahead with the calendar. The first bill is House Bill 53 by Speaker Pro Tem March. Is there a motion on the bill? Is there a second? Motion is second. Speaker Pro Tem March, you're recognized.
Thank you, Mr. Chairman and committee members. House Bill 53 simply renews the T-Dot Little Grant program. The T-Dot Little Grant was authorized in 1980 and funded by the excise tax on beer and the gross receipts tax on bottled soft drink. The funding for the program will expire without the renewal. Some of the facts are there's between $6 and $8 million collected each year for this fund, and every county gets a part of it, ranging from $44,000 to $269,000. So they use that money to pick up litter, do educational programs, to let prisoners go out and beautify our streets and roads, and I highly recommend we do this.
Question's been called. Is there objection to the question? Hearing no objection, we're voting on House Bill 53. All in favor say aye. Aye. Opposed say no. Ayes prevail. Thank you, Mr. Speaker.
Thank you, Mr. Chairman. Thank you, committee.
Moves on to the next available calendar of local government. The next bill on the calendar is Bill 182 by Representative Jernigan. Is there a motion? There's a motion and a second on the bill. Representative Jernigan, you're recognized on House Bill 182.
Thank you, Mr. Chairman. Members, House Bill 182 prohibits a local beer board and the ABC from imposing reciprocal fines and penalties on a licensee or a permittee based solely on the fact that their respective entity provided notice for such a penalty. In Tennessee, the state regulates liquor and the locals regulate beer, and they're granted authority to do so in separate parts of the code. And that's the fact that we're in local government today means we're dealing with beer. The current law says if the ABC takes any action against an entity with an LBD license and a beer permit, that the ABC shall provide notice to the local beer board, and that's fine. I think notice should go to each entity to let them know what's going on in their district, in their business. But after the local beer board receives notice, it's then authorized to suspend the beer permit, or in lieu of suspension, issue a fine under 575108. Then they shall have a hearing to provide an opportunity for the permit holder to come down and then show cause on why they should not suspend, fine, or revoke the license. So basically, the beer board has the authority to temporarily suspend a business permit in lieu of suspension or fine based solely on the notice that an entity doesn't issue from an entity that doesn't issue beer permits. Then the beer board's required to hold a hearing for the owner to show up and show cause. That, frankly, is you're guilty until proven innocent. So the last thing, that nothing in this bill prohibits the ABC or the beer board from independently conducting their own investigation or their own sting operation. So what we're trying to do is to limit really fining a business twice for the same violation. So I'm open to questions, and I think there's testimony. So,
Mr. Sponsor, we do have someone who has requested to testify today, so we're going to go out of session. Is Mr. Rummage here to testify? If you'll come forward, sir, introduce yourself to the committee, and you'll have 3 minutes. Yes, you can go to the microphone. That's for the record, please introduce yourself.
Yes, sir. Thank you.
We're going out of session.
Aaron Rummage with the Tennessee Alcoholic Beverage Commission. First of all, I just wanted to give a little background on how the TABC conducts their how we provide due process to our licensees and a little bit about the case law, current law in Tennessee. Currently, any beer permit holder or TABC licensee, once they get that license issued to them, they have a property interest in that permit or license, and so that would afford them due process through the U.S. and Tennessee Constitution. So if we are to penalize, suspend, fine, revoke them, they have to have a hearing. It goes for fines, both beer boards and the TABC. Has to be based on evidence. So for instance, if the beer board finds something that occurred, or like the local police find a state violation has occurred, we can call that evidence into, in front of our commission. And that evidence, our decisions can't be arbitrary. So if somebody is upset about the decision, they can appeal it to the local circuit court. So I just want to get that kind of out there, just so you know, if we issue something, it's gone through, we're covered by the UAPA too. So it's really like a judicial, the finding is been by our commission or by administrative law judge. Evidence has been deemed by us or that judge to be sufficient to warrant a suspension. And then currently right now the beer board can call those witnesses in. So they, we'll have notice about the citation, but they will then call those witnesses in, and because they also have to give due process, they'll have a hearing. So if they go to take the beer permit, they'll have that hearing. I guess we are there is an unintended consequence that could occur. A lot of times in your rural areas, we are the only ones that actually do the minor compliance checks to a great extent. The local beer boards there mainly could be the county commission, but they don't have inspectors. So they rely on us to provide them that information about minor compliance checks. And we've been working with the local beer board since 1967. That's when they first passed liquor by the drink. And so we share liquor by the drink licensees and our retail food store licensees. And so a lot of times in rural areas, they just don't have the inspectors to do it. So if they're not able to call that evidence in and call our agents in, then there could be a time when you lose your liquor license and not your beer permit. So we've, if we've taken the license, we've deemed it to be kind of a risk to public service.
Thank you, Mr. Rummage. Your time's expired.
Okay.
Do any of the members of the committee have questions for Mr. Rummage while he's up? Representative Miller, you're recognized, sir.
Thank you, Mr. Chairman, and thank you. Just a hypothetical. If ABC, let's say, were to fine an entity $1,500, could a local billboard fine that entity an additional $1,500 on the same offense?
Mr. Rummage, you're recognized.
That you mean under the same set of facts, like if we run a minor compliance check and we write a ticket, a violation of state law for selling to a minor, can they also fine?
Yes.
Yes, okay. Yes, sir. The current law, so if you have a TABC license and a beer permit, the current fine or current penalty for selling to a minor is the TABC fine and the beer board fine. Both have rules against breaking state law, so there's a responsibility. When you get your beer permit, you have a responsibility to them. There's local ordinance that allow them to fine based on a violation of state law, and same with us. If a local ordinance is violated or state law is violated, we issue that fine. So we are the, we were kind of like the state alcohol police, and they have the local police, both have jurisdiction over alcohol violations. So if the local police find something, we can use that evidence. If we find something, the beer board can use that evidence.
Representative Miller.
Thank you. He's answered the question. Thank you.
Any other members have a question? Thank you, Mr. Rummage. We'll go back into session.
Thank you.
We're back on the bill. The sponsor's recognized.
Thank you, Mr. Chairman. So I'm not saying that the ABC and the beer board is going to love this bill because it's very convenient for them. But I can tell you that every restaurant that has a bar, every Chili's, Applebee's, O'Charlie's in your district is going to welcome the regulatory relief of being hit twice for the same violation. And so it's not, and from what the ABC just said about the locals having to follow state law, we're getting rid of the law so they don't have to do it. So it's a may. My problem is that I need each of them to do their own investigation. If the ABC goes down and they hit a business and they fine them, and rightly so if they've broken the law, and they give a notice to the beer board, well, then the beer board needs to do their own investigation. Maybe that business fired the bartender, and there's no longer a problem. But we don't need to suspend or fine them based on something that's already been solved. So it's really, and to have a hearing 2 weeks later, and you've suspended that business, how much revenue have they lost? And they're innocent to come down. So the due process that he's talking about is due process after you've already suspended, fined, or revoked their license. That's not due process. That's guilty until proven innocent. So that's what I'm trying to change, just to have both. I can't help that liquor's the state and locals is beer, but that's what we have. And this is not about convenience. This is about due process and what's right for the business owner. So with that, I'm happy to take questions as well.
Members have questions for the sponsor? Representative Chisholm, you're recognized.
Thank you, Chairman, to the sponsor.
Yep.
So under this bill, both entities, they're still able to share information. Am I correct?
They are.
Okay. But this bill will require that they do independent investigations, right?
Sponsor.
They have authority to do so.
Okay. So as it goes currently, if one finds a restaurant, for example, the other one can automatically find them as well?
Yes.
Sponsor.
Okay.
They do.
Okay, thank you.
Any other questions? We ready for the question? The question's been called. Is there objection to the question? Hearing no objection, all in favor of the motion of the bill say aye. Aye. Opposed say no. No. Call the roll, Mr. Hutchison.
Vice Chairman Calfee? No. Representative Chisholm?
Aye.
Chairman Crawford? Aye. Leader Gant? Chairman Helton?
No.
Representative Miller? Aye. Vice Chairman Wright?
Aye.
Chairman Moon?
No.
Mr. Chairman, 4 ayes, 3 noes.
Ayes prevail. Moves to the next available calendar, local government.
Thank you, Mr. Chairman. Members.
Next bill is House Bill 701 by Chairman Whitson. The chair does have an original resolution of the Franklin Special School District requesting this action. Motion on the bill. Is there a second? Is there a second? Second. There is a second. Motion second. Chairman Whitson, you're recognized on House Bill 701.
Thank you, Mr. Chairman and committee. House Bill 701 is a private act. What this will do is authorize the Franklin Special School District of Williamson County to issue and sell school bonds in the amount of $45 million. This will be used for new construction, rehabilitation of current facilities and such across the district. This resolution, as the chairman noted, was approved by the school board on their regular meeting of 9 November 2020, and I have copies of that if any member needs it. With that, Mr. Chairman, I renew my motion.
Are there any questions for the sponsor? Question being called on the bill. Is there objection to the question? Hearing none, we're voting on House Bill 701. All in favor say aye. Aye. Opposed say no. Motion carries. It moves to the next available calendar in local government. Thank you.
Thank you, Mr. Chairman and committee.
Next bill on the calendar is House Bill 1097 by Representative Vaughn. Is there a motion on the bill? We have a motion. We have a second? Second. Motion second on the bill. Representative Vaughn, you are recognized on 1097.
Thank you, and I think we've agreed to roll House Bill 1097.
Sponsor request to roll Bill 1097. Is there objection? Hearing no objection, it's been rolled for 1 week. Next item on the calendar is House Bill 657 by Representative Vaughn. Is there a motion on the bill? Motion. Is it motion and a second? Representative Baum, you're recognized on House Bill 657.
Thank you, Chairman Moon. This is a bill with 23 sections that updates the local government finance statutes. I'm carrying this on behalf of the Comptroller's Office, and let me give you a sense of what's contained in these statutes. There's an attempt to modernize some of the language. Currently, these statutes contain some outdated terms and some provisions that have been sunset. For example, in these statutes is the term abattoir. There may be someone in here who wonders what that is. It's a slaughterhouse for chickens or cattle. Evidently, in the current code, it's possible to finance a city or county-owned abattoir. That doesn't occur, and so that language and other terms are being either removed or modernized. This bill also simplifies borrowing procedures that are currently burdensome or not very user-friendly. For example, interfund capital outlay notes can currently be issued for a 3-year period and then can be extended for 2 subsequent 3-year periods. But each time these have to be reviewed and approved by the Comptroller's Office. The revised language in this bill would allow these capital outlay notes to be issued for a period of 12 years without the renewal process and the reviews in between. As a third example, this bill will increase transparency. Currently, it's possible, and there has been one instance where a local entity issued capital outlay notes for a long-term capital project in order to avoid a referendum, only to convert those capital outlay notes to a long-term bond. Here's why that happened. Voters have the prerogative to call a referendum whenever a long-term capital project is being financed with long-term bonds. But they don't have that prerogative for a capital outlay note, so the way a county entity was working around that was, again, issue the capital outlay note, avoid the referendum, and then convert it to a long-term bond. The language in this bill makes it clear that that's not permissible. The appropriate approach is to simply issue a long-term bond or a bond anticipation note. And let me give one more example of the kinds of things that are in this bill. It updates certain ways that you can issue debt. It would make it permissible for a county or city authority to issue a variable rate revenue bond and then to convert that to a fixed rate bond at some point. That's currently not permissible, but that would benefit our local citizens because it would insure against risk, moving from a variable rate to a fixed rate. Some of the provisions in here benefit our citizens in other ways, for example, not having to issue debt multiple times. That would save on some fees. Let me pause at this point and see if you have questions. Again, there are 23 provisions in here, and I suspect you don't want me to comment on all of them. That gives you a flavor of what's in the bill, and I'm happy to answer any questions.
Thank you, Mr. Sponsor. Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. Simple question, Representative Baum, on this, the bill that you're bringing now. Is there any pending litigation that your bill would have an effect on if it goes into effect?
Mr. Sponsor.
Not that I'm aware of. I haven't heard anything about that, no.
Thank you, Mr. Chairman.
Any other questions from the members? Is there objection to the question? Hearing no objection, we're voting on House Bill 657. All in favor say aye. Aye. Opposed say no. The ayes prevail. It moves on to the next available calendar in local government. Thank you.
Thank you all very much.
The next bill is House Bill 327 by Vice Chairman Wright. Is there a motion on House Bill 327? Is there a motion and a second on House Bill 327? Vice Chairman Wright, you are recognized.
Mr. Chairman, may I present from my seat?
You may, without objection. Hearing no objection, proceed.
Thank you, Mr. Chairman. Sort of a thumbnail sketch of where we are today in an era of changing technology. For example, here in the House, we no longer have paper to carry around. We're supposed to be carrying these props. And with the current circumstances, healthcare related in the pandemic, technology has brought forward better presentations and access to the public. It's better than ever. In an effort to keep this transparency and provide for representation, and I say that in the word of keeping the legislative member involved in making policy, here's a straightforward approach to use of technology for county legislative bodies as currently used by boards of education, state committees, and state boards. Bill has two parts. Is related to members. The member must be out of county on the job, a medical emergency, or a call to military service. So in light of those three criteria, or those three occurrences, following criteria has to be observed. Quorum has to be physically present. And if it's a work-related, there must be a 5-day notice. And it can only occur twice a year, except in case of military call-up. And with that thumbnail sketch, I would stand, or I will be seated for questions.
Thank you, Ms. Sponsor. This time, I'd like to go out of session. Ms. Deborah Fisher from the Tennessee Coalition on Open Government would like to do testimony. If you'll come forward. And for the record, if you'll introduce yourself, we're out of session.
I am the Executive Director of Tennessee Coalition for Open Government, and we do education and advocacy on the open records and public records, open meetings and public records laws. And this bill would create an exception to the Open Meetings Act. If we were not in a pandemic with a governor's order allowing electronic meetings, Section 108 of the Open Meetings Act would govern electronic participation in meetings, broadly speaking. And I'm really here to speak to you from the public's point of view, not from the county commissioner's point of view. And we've learned some things during the pandemic, during electronic meetings. Some meetings have gone well, some have not gone well. There's some specific things in this bill that I think are not good for the public. The public needs assurance that they will be able to hear and follow along a meeting. This would apply for county commissions, and some county commissions are quite large. They are 24, 25. So a physical quorum present physically would still allow quite a number of commissioners to patch in by phone electronically. And probably the biggest complaint that we've had during the pandemic is when you have people in a governing body patching in by phone, it's hard to follow who is speaking. You don't really know. Section 108 does cover that in terms of looking for a roll call vote, and it has some audibility concerns. Again, this is an exception, not just to Section 108, but to the entire Open Meetings Act. Anything that conflicts, in other words, with the Open Meetings Act, this bill, the language in this bill would trump. So I think that we need to think about, and just go slowly and carefully on this, that, and think out the different scenarios, because this is not just for the pandemic if it, continues past April, May, June. This is for post-pandemic. There are some things that we think could improve the bill, which would be to limit the number of people who could call in on the phone, so you could better understand, have more video. And this bill, even though more people have been able to, from the public, participate in governing body meetings electronically, this bill does nothing for the public. It does not allow the public to patch in. So it's really just about the commissioners. You know, the bill is modeled after what the school boards have. It does expand it slightly. The school board has family emergency. This adds medical emergency. And then it says that the local governing body can determine what that is. And with the Open Meetings Act, I think that we should proceed there with caution.
Ms. Fisher,
Am I
time's
done?
expired.
Okay.
At this time, do any members have questions for Ms. Fisher? Representative Miller, you're recognized.
Yes, sir.
Thank you, Mr. Chairman. Did I understand you to say that under these circumstances, the language in the bill would not allow the public to participate?
Ms. Fisher?
Would not allow, what I meant to, maybe I can clarify, it would not allow the public to participate electronically. It just allows the commissioners to participate electronically.
Representative Miller? Just a moment. Just a moment. Representative Miller?
Well, thank you, Mr. Chairman. I heard Chairman Crawford whisper over there is not true.
If we'll defer, we'll recognize legal analysts. If you'll identify yourself, Mr. Garrett.
Thank you, Mr. Chairman. Doug Garrett with the Office of Legal Services. I was talking and I presume that the question involves input or the creation of language dealing with public input. In subsection E, in section 1, it does say that the county legislative body shall develop a policy for conducting meetings with electronic participation.
Thank you, Mr. Garrett. Representative Miller, you have the floor, sir.
Thank you, Mr. Chairman. So that question has been answered by our legal. Thank you,
Ms.
Mr. Chairman.
Miller. Ms. Fisher?
Well, just to respond, the statute does not require the county governing bodies to allow the public to participate electronically. It allows the county legislative body to develop a policy. But that policy, it's not required that the policy, it doesn't say that it requires that the policy require the public to be able to patch in electronically. It just says develop a policy. That's how I understand it.
Yes. Representative Miller?
Thank you, Mr. Chairman. I understand it much better based on what legal has said, what you're saying. So
Okay.
next questions will be for once we're back in session for the sponsor.
Thank you, Thank you, Representative. Any other questions to Ms. Fisher? Seeing none, thank you.
Thank
We'll
you.
go back into session. We're back on the bill. Leader Gant, you're recognized.
Mr. Chairman, I wanted to apologize for my tardiness. I had another bill in another committee that we were trying to work through some issues, so thanks for letting me be late. So apologize.
Duly noted. Any other questions on the bill? Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. I just wanted to go back to Representative Miller's question there. Within the bill, it does require each county commission or whatever entity is doing this, they have to come up with some guidelines. And I think that's where the public would come in and say, hey, we want access to this. And I think she said a certain amount of people calling in. I think under the guidelines is where all that would be stipulated. I don't think we need to legislate from the state what each local government needs for themselves to participate. The other thing I wanted to say is I would like for the sponsor of the bill to answer the question and clarify, is this for only county commission meetings, the main meetings, or would this involve their committee and work sessions?
Vice Chairman Wright.
Thank you, Mr. Chairman, and Mr. Chairman for the question. This would just be the regular stated monthly meeting of the county elected body.
Chairman Crawford.
Follow up, so that means that this would not apply to their regular committee meetings or work sessions. They would be required to be there in person and establish their quorums in that way.
Vice Chairman Wright.
Thank you, Mr. Chairman. My presentation envisions that, but now, if what is here on paper or on my my iPad, I would need a legal opinion of that, Mr. Chairman, as to the interpretation then to follow his question.
Go out of session, recognize Mr. Garrett.
Thank you, Mr. Chairman. Doug Garrett again with legal. There are multiple references to either a scheduled commission meeting or a commission meeting itself. It doesn't mention committee meetings or any other ancillary meetings that may occur.
Okay, we're back in session.
Thank you, Mr. Chairman. So in light of that, let me back up to the beginning of the bill. And the subparagraph 1, speaking to the elected member, the word there is may. Skipping down to the middle of the page of speaking of medical emergency, that's as defined by the county legislative body. And then the last lettered point is E. This policy is made up, enacted by the legislative body itself. So if they want to cover just monthly meetings, it would be my opinion that they could cover whatever meetings they want to cover, or cover no meetings if they don't want to have but they will have a policy. The policy could be to have no policy. So all of what we're discussing right here today is a way of having electronic meetings, but allowing that to be determined by the local legislative body.
Chairman Crawford.
Thank you, Mr. Chairman. My question would be for Mr. Garrett then. Due to what we've just heard, I think the intent of this bill will now be on record, and if there's any question to the intent of it, we can always go back and review that.
We'll go out of session. Mr. Garrett?
Doug Garrett with legal. I can't speak to the intent of the bill, of course, but it does specifically say, on paper, it does specifically say scheduled commission meetings and commission meetings. It does not speculate or it does not address the issue of any other meeting.
Okay, we're back in session. Chairman Crawford?
Thank you, Mr. Chairman. I think all my questions have been answered, and I appreciate the sponsor taking time to explain his intent on that. Thank you.
Representative Miller, you wish to be recognized?
Thank you, Mr. Chairman. And to follow up somewhat, is it my understanding that this can only occur twice?
Vice Chairman Wright?
Thank you, Mr. Chairman. Yes, fellow representative, it is to occur for an individual only twice in a year.
Representative Miller?
Hypothetically, Shelby County, there's 13 commissioners, so each commissioner would have twice to be involved electronically.
Vice Chairman Wright?
Thank you, Mr. Chairman. For those 3 described occurrences, commissioners work out of county, medical emergency is determined by the legislative body, or being called into military service. That's the only 3 occurrences this covers. And they could have 2 of those per year.
Representative Miller?
Thank you. That's such a great sponsor. But I'm open to the concept and the idea of this, but it doesn't cover city council members or obviously state legislators or any other elected positions. We're only talking about county commissioners.
Representative Wright? Vice Chairman Wright?
Yes, thank you, Mr. Chairman. County legislative body. County legislative body. So we might have to go somewhere to get a definition of that. It does not say county commission. It says county legislative body.
Representative Miller.
I'm not sure if we need another interpretation by the attorney, but that would include county mayors, county legislative bodies.
Correct,
only.
sir.
So it wouldn't include city council members or any other at this point.
Any other?
Thank you, Mr. Chairman. County legislative body would not be city council.
Correct.
But county legislative body may be metro government.
Okay. Thank you, Mr. Chair.
Any other questions from the members? Is there objection to the question? Hearing no objection, we're voting on House Bill 327. All in favor say aye.
Aye.
Opposed say no. The ayes prevail, and House Bill 327 moves to the next available calendar of local government. At this time, does anyone have any announcements? Seeing none, without objection, this meeting is adjourned. Hearing no objection, we are adjourned.